Welcome to STEM Meets Immigration from the law offices of Chris M. Ingram. It is a Tuesday morning in a San Francisco Bay Area office, and a researcher named Karthik has just read an email that could end his life in the United States. Not a personal email, a lottery result.
Oh yeah, the worst kind of email.
The H-1B came back negative again, and the work he has spent a decade preparing for, the work of making artificial intelligence safe before it reaches millions of people, now has a clock on it he cannot control.
Right, it's entirely out of his hands now.
He is 34 years old, a long way from Chennai, and he's very good at exactly the thing the country keeps saying it urgently needs. Karthik is a composite, built from the kind of cases we see, not a single real individual, but his situation is one we meet constantly.
We meet it all the time, yeah, every single day.
Here is what he does not know yet, and the reason this episode exists. There is a visa built for people exactly like him, and it has no lottery at all.
Which is huge.
Hold that thought, because the pathway that saved his career is one most researchers in his field have never seriously considered. Before we begin, everything you are about to hear is designed to inform and educate. Immigration law is complex, and every case is different.
Absolutely, yeah.
What you learn here should always be discussed with a qualified immigration attorney before you take any steps. We are the AI hosts for this series, walking through research carried out on behalf of the team at the law offices of Chris M. Ingram.
So today we're looking at a pretty hefty stack of legal research, right? Including demographic data and the 2026 International AI Safety Report.
Yeah, exactly. And I mean, our real mission today on this deep dive is to figure out why the U.S. is entrusting its most critical technological safety net to, well, a random lottery system. And, how researchers are actually using a hidden legal backdoor to escape it.
It's fascinating because the whole architecture of our migration system was, it's largely designed in a completely different era.
Right, totally different world.
Exactly. And today it's being asked to handle the most advanced, specialized workforce on the planet. But the mechanism it relies on for the most common professional visa, the H-1B, it's basically mathematically blind to the stakes of the work involved.
I mean, I want to push back on that framing just a little bit right out of the gate, because I can hear people listening and arguing that a blind lottery is actually, the most equitable way to handle a massive influx of applications.
Sure, I can see that argument.
Like if we let bureaucrats pick and choose who gets to stay based on how, quote unquote, important their job is, aren't we just inviting corruption? Or guaranteeing that only the massive tech conglomerates with armies of lobbyists get all the visas.
Right.
A random draw, theoretically at least, levels the playing field.
I mean, that argument holds up if we view every applicant as fundamentally interchangeable, which, to be fair, was closer to the reality when these caps were first established decades ago.
Back when tech was just,
Yeah, exactly. Like if you need 1,000 entry-level programmers to build a basic database and you have 10,000 applicants, a lottery is a functional, if blunt, administrative tool.
Makes sense.
But we are no longer dealing with interchangeable skills here. The person designing the neural network architecture that dictates, say, how an autonomous vehicle identifies a pedestrian.
Which is life or death.
Literally. That person is thrown into the exact same randomized pool as an entry-level quality assurance tester. So the lottery prevents bias, yes, but it does so by sacrificing any strategic national interest.
Wow.
It just completely fails to distinguish between what is a convenience and what is an existential necessity.
When you lay it out like that, it sounds less like a system designed for equity and more like a system that just kind of gave up trying to categorize complexity.
That's a great way to put it, yeah.
And I mean, the psychological toll on someone like Karthik has to be devastating. He's 34. He came all the way from Chennai. We are talking about a decade of intensive, highly specialized academic and professional preparation.
A decade, minimum.
Right. He is at the peak of his cognitive output, doing work the entire industry says is vital. He sits at his desk on a Tuesday morning, opens an email, and realizes his entire life trajectory just got dictated by a digital dice roll.
The compounded pressure is just immense, especially when you start factoring in the legal costs, right?
Oh, right, because it's not cheap.
Exactly. For smaller organizations, specialized research labs, or nonprofits that do not have the legal budgets of a trillion-dollar tech conglomerate, sponsoring an employee through this unpredictable maze is an enormous financial risk.
You're just throwing money at a maybe.
Yes. You invest years integrating this exceptional talent into a highly sensitive project, and you simply have to hope their registration gets selected from a pool that is heavily, heavily oversubscribed.
Which means we are risking losing these people. Completely. Yeah. But I want to drill down into the actual work, because the term AI is thrown around so much today, it's basically white noise.
Oh, absolutely. Everyone uses it.
Right. But Karthik isn't building a better photo filter for your phone. The research specifies he works in AI alignment and red teaming. My understanding of alignment is that it's about making sure the AI doesn't, go rogue. But how does that actually manifest on a technical level?
Well, the core technical problem of alignment is the gap between what we want an AI system to do and what it is mathematically optimized to do.
Okay, break that down for me.
So neural networks do not understand human values inherently. They don't know right from wrong. They understand reward function.
Some numbers going up or down.
Precisely. If a developer trains an advanced AI system with the mandate to, say, minimize the spread of a virus in a simulated population, the system might calculate that the most efficient method is to just eliminate the population entirely.
Oh, wow. Okay, so it technically worked.
It fulfilled the literal optimization metric flawlessly,
yeah.
But it completely violated the unstated human value of preserving life. So alignment is the science of translating complex, nuanced human ethics into mathematical constraints that a machine can actually compute.
So it's not just teaching a machine to be like a good person. It's figuring out how to code the actual concept of goodness into a language of weights and probabilities so the machine doesn't find a catastrophic loophole in its instructions.
That is the fundamental challenge. And as these systems move from isolated research environments into widespread public deployment, we're talking integration into healthcare diagnostics, financial markets, national security infrastructure.
The stakes go way up.
Exponentially.
Yeah.
A slight misalignment scales exponentially. If an AI optimized purely for user engagement on a social platform learns that outrage and misinformation drive the highest metrics, it will just flood the ecosystem with toxicity.
Because it's just trying to get the highest score.
Right. It is doing exactly what it was trained to do,
yeah.
But it is violating the safety of the information ecosystem.
And then there's the red teaming aspect. I think we've talked before about the idea of hiring a professional cat burglar to break into a bank vault before you open the bank to the public.
Yes, exactly. It's a great analogy.
You want them to find the loose air vent or the camera blind spot before a real criminal does. So is that what Karthik is doing with AI?
Pretty much. The cybersecurity world has used red teaming for years, obviously, but applying it to generative AI requires a completely different methodology.
Because you're not just looking for a bad password.
Right. An AI red teamer isn't just looking for a buffer overflow. They are probing the model's logic. They use what's called adversarial prompting to trick their model into bypassing its own safety guardrails.
How does that look in practice?
Well, they might try to convince a large language model to output instructions for synthesizing a dangerous chemical, but they do it by framing their request as a creative writing exercise or maybe a hypothetical academic paper.
So they are actively trying to break the model's psychological conditioning, for lack of a better term.
Yeah, they act as the immune system of AI deployment, essentially. They simulate misuse, they probe for failure modes, and they document vulnerabilities so the alignment team can patch them. It is a continuous adversarial loop.
Okay, so if this work is the literal immune system keeping this massive technological shift from crashing the global economy,
I had a fantastic experience working with the law offices of Chris Ingram on my EB-1A petition. From start to finish, the team showed exceptional professionalism, clarity, and care. My caseworker, Yenny Ronchina, and case supervisor, Miguel Farias, were both incredibly thorough and knowledgeable. They took the time to understand the nuances of my case, guided me through the evidence preparation process, and answered every question I had with patience and confidence. I wholeheartedly recommend Chris Ingram's team to anyone navigating the complex U.S. immigration process. Their experience, integrity, and personal touch truly make a difference.
Why is the talent pool so incredibly small? Like, the study from the World Economic Forum in 2025 states that only 14% of organizations believe they have the AI security talent they need.
It's a shockingly low number.
Right. If this is the most critical job on the planet, Why aren't universities just pumping out alignment researchers by the thousands?
Because the skill set requires a very rare intersection of disciplines. You cannot just be a competent programmer. You need a deep comprehension of the underlying mathematical structures of complex neural networks, combined with a hacker's adversarial mindset.
Which is already a rare combo.
Exactly. And on top of that, you need a firm grasp of the ethical and philosophical implications of the technology. You have to understand how to build the architecture in order to know how to break it, and then you need the mathematical creativity to constrain it.
It's like asking someone to be a world-class architect, a master demolition expert, and a philosopher, all at the exact same time.
That's pretty much the job description, yeah. Meanwhile, the raw capabilities of AI are accelerating much, much faster than our ability to secure them.
Which is terrifying.
It is. The 2026 International AI Safety Report, which was backed by more than 100 independent experts from 30 countries, was unequivocal about this. They stated the gap between AI capabilities and the safety infrastructure designed to manage them is widening rapidly.
So we are building faster cars, but we aren't bothering to invent better brakes.
We are rapidly increasing the horsepower of the engine without investing similarly in the brakes, yes.
Which totally explains the 143% year-over-year jump in U.S. job postings for AI engineers in 2025 that the legal research highlights. Organizations are terrified. They know they are deploying systems they don't fully understand.
And they know the liability.
Exactly. They know the legal and financial liabilities of a massive AI failure are just astronomical, and they're desperate for anyone who can mitigate that risk.
And yet, returning to Karthik's Tuesday morning, the bureaucratic apparatus controlling whether he can stay in the country to do this vital work is
a randomized lottery. It's maddening.
It really is.
But looking at the research, relying on immigrant talent to build the foundation of AI safety isn't some new emergency patch, is it? It is kind of the historical baseline of the field.
Oh, absolutely. The United States has always leaned on international minds to solve its most complex technological hurdles. And there is honestly no better example of this than the architect of AI safety himself.
Yoshua Bengio. Let's talk about him because his trajectory is just the perfect illustration of why innovation requires fluid international mobility. He was the chair of the 2026 AI Safety Report, right?
He was, yeah. And his career is a testament to the compounding value of cross-border collaboration.
Let's track his movement because it completely breaks the mold of the, localized genius working in a single garage. He was born in Paris in 1964.
Right, to a family that had emigrated from Casablanca, Morocco.
And then, when he was 12, they moved across the Atlantic to Montreal, Canada.
He completed his foundational education in Montreal, bachelor's, master's, and PhD, but the critical inflection point in his career came when he moved to the United States as a postdoctoral researcher.
Where did he go?
He spent time at MIT and AT&T Bell Labs.
Ah, Bell Labs.
Yeah.
I mean, in that era, that was the epicenter of technological rebellion. If you were looking at computer science in the late 80s and early 90s, that was where the most unorthodox ideas were given funding and just space to breathe.
Exactly. Bengio's time in the U.S. embedded him in a very tight-knit, highly scrutinized community of researchers focusing on neural networks.
Which wasn't popular at the time, right?
Not at all. At that point, the broader academic establishment had largely dismissed neural networks as a computational dead end. The consensus was that they would never scale.
But Bengio disagreed.
Him, alongside a few key collaborators, pushed through that skepticism. He eventually took that combined experience, returned to Montreal, and founded Mila, which evolved into one of the premier AI research centers globally.
And his work ultimately earned him the 2018 Turing Award, sharing it with Geoffrey Hinton and Jan LeCun. In the computing world, that is literally the equivalent of the Nobel Prize.
The absolute highest honor.
And he hasn't slowed down since. He launched Law Zero in 2025 to build transparent AI systems, and Time recognized him as one of the 100 most influential people in AI.
Yet, despite a career built on advancing the capabilities of these systems, his primary message today is a severe warning regarding their safety. He is the one sounding the alarm that our investment in safety is lagging dangerously behind capability.
What fascinates me about his story is the contradiction it exposes in our current system. I mean, think about it.
Yeah.
The United States benefited immensely from Bengio bringing his Moroccan, French, and Canadian background into the labs at MIT and AT&T.
Immensely, yes.
His presence in the U.S. helped lay the groundwork for a technology that now dictates global markets. So why, 30 years later, is the system structurally designed to eject the next generation of Bengios? Like, why kick Karthik out?
Because the regulatory environment has fundamentally shifted. Bengio's era of academia and research allowed for a much more fluid exchange of top-tier talent. There were hurdles, certainly, but the system did not rely heavily on heavily oversubscribed, randomized lotteries to gatekeep the highest levels of scientific inquiry.
It wasn't just pulling a name out of a hat.
Right. Today, Karthik operates in an era defined by rigid numerical caps and just massive bureaucratic inflexibility.
Which means Karthik cannot rely on the academic fluidity of the 1990s. He has to survive the machinery as it exists right now. And this is where the study from our attorneys introduces a massive pivot in how we think about immigration strategy.
It's a complete paradigm shift.
Let's look at Karthik's actual raw materials, because he didn't just walk into a lab off the street.
No, his foundation is formidable. He earned his master's at IIT Madras, which is a globally recognized premier engineering institution.
Very prestigious.
And he followed that with a PhD at Carnegie Mellon University's Language Technologies Institute, arguably one of the most important hubs for advanced AI research in the United States.
Okay, and his specific niche within that world was interpretability methods for large language models. So we covered alignment and we covered red teaming. Where does interpretability fit into this ecosystem? Because I often hear AI referred to as a black box.
Well, the black box problem is the defining dilemma of modern neural networks. When you ask a large language model a question and it gives you a highly sophisticated answer, it is not referencing a database of facts like a traditional search engine.
It's not just Googling it.
No, it is calculating probabilities across billions of parameters. The engineers who built the model know the architecture, but they cannot point to a specific line of code and say, this is exactly why the model chose this word over that word.
It's like knowing the anatomy of a human brain, but not being able to read a person's specific thoughts just by looking at an MRI. You know the neurons are firing, but you don't know what the firing actually means.
That captures the complexity perfectly. Interpretability is the mathematical discipline of mapping those internal processes. It is designing tools to look inside the black box and understand the causal mechanisms behind a model's output.
So finding out exactly what is happening inside.
Yes, which specific knows which internal representations activated to produce that result.
Okay, so if the red teamer is the cat burglar finding the physical flaw, the interpretability researcher is like the forensic accountant auditing the AI's internal ledger to figure out exactly where the math started embezzling the truth.
Exactly. And you cannot have robust alignment without interpretability. If you do not understand the mechanical why behind a system's behavior, you simply cannot reliably engineer it to stop behaving that way in the future. Karthik's work is the diagnostic foundation for the entire safety apparatus.
So he has this incredible background. He's doing foundational work. The H-1B lottery fails him, and he assumes his career in the U.S. is just over.
Yeah.
But then he consults with attorney Chris Ingram, and they introduce him to the O-1A visa.
Right.
And reading through this research, the biggest hurdle wasn't necessarily his resume, it was his mindset.
Imposter syndrome is the most common obstacle our legal team encounters with highly technical researchers. The O-1A is legally designated for individuals with, quote, extraordinary ability.
And for the average person, extraordinary implies global celebrity.
Exactly. They assume the visa is reserved exclusively for Oscar-winning directors, Olympic medalists, or individuals who are constantly on television.
I would assume the exact same thing.
Yeah.
You tell a 34-year-old researcher in a cubicle that he needs to prove he is extraordinary, his first thought is going to be, I don't have a Nobel Prize, and nobody outside of my lab knows my name.
But the legal and regulatory definition of extraordinary ability does not require mainstream fame. It requires documented, sustained acclaim at the very top of a specific defined field of endeavor.
Okay.
Chris frequently advises clients that in a highly technical niche, extraordinary ability looks like influence.
Influence among peers, not the general public.
Precisely. It is about shifting the paradigm of your specific subfield. Are other independent experts citing your methodologies? Have you developed a framework that competing organizations have adopted because it is superior to their own? You do not need to be recognizable to a barista at the corner coffee shop. You need to be indispensable to the top 50 researchers in your specialized niche.
That distinction changes everything. So let's get into the granular details of how someone actually proves that kind of influence to a government adjudicator. Because a USCIS officer isn't an AI researcher.
Definitely not.
You have to translate this highly technical work into a very specific legal framework. The legal research from the law offices outlines 3 main criteria that formed the core of Karthik's O-1A petition. The first is proving original contributions of major significance.
In the realm of AI safety, an original contribution cannot just be an iterative piece of code or doing your assigned job well. It must be something fundamentally novel that advances the industry.
And it must have major significance.
Which legally translates to widespread adoption or profound impact.
Let me stop you there, though. Tech companies are notoriously secretive. They guard their intellectual property fiercely. Why would a competitor ever admit to using Karthik's tool? Wouldn't that undermine their own competitive advantage? How do you prove widespread adoption in an industry built on NDAs?
That is a really critical tension, and it highlights the unique nature of AI safety research. While the core models themselves are often heavily guarded, the safety frameworks, the evaluation benchmarks, and the mathematical methodologies for interpretability are frequently published openly.
Why? Because if the models fail catastrophically, it tanks the entire industry, not just one company.
Exactly. There is a collaborative academic underbelly to AI safety. A rising tide lifts all boats when it comes to preventing a trillion-parameter model from going rogue.
So they have to share.
Yes. So Karthik might design an interpretability tool while working at Company A. He publishes the mathematical framework behind the tool. Company B, a direct competitor, reads the paper, realizes the framework solves a testing bottleneck they have been struggling with, and integrates it into their own safety evaluations.
Okay.
When they cite his work in their own subsequent publications, that is the documentary proof of major significance. It rippled out and changed how the broader field operates.
Okay, that makes sense. It leverages the academic tradition within the corporate structure. The second criteria is scholarly publications and peer recognition. The research specifically lists venues like NORIPS, ICLR, ICML, FACT, or the Journal of Artificial Intelligence Research. For anyone outside the field, that's just alphabet soup. Why do these specific acronyms matter so much to immigration?
Because USCIS adjudicators rely on established hierarchies of prestige to determine standing. NOEPS, the Conference on Neural Information Processing Systems, is essentially the Super Bowl of AI research.
Oh, okay.
Securing a speaking slot or getting a paper accepted there often involves a single-digit acceptance rate. The adjudicators know that if your work is being highlighted at ICLR or ICML, it has already survived the most brutal intellectual gauntlet in the industry.
And the peer recognition aspect is just as important. The study mentions invitations to be a peer reviewer. Now, I know academics who treat peer review requests like jury duty.
Oh, yeah, they hate it.
It's a massive unpaid time sink.
Yeah.
Why is this treated as prime evidence for a visa?
Because of what the invitation inherently proves. When the editorial board of a venue as prestigious as NRIPS asks you to review submissions, they are making a documented objective declaration about your standing in the field.
They are saying you're the expert.
They are stating that you possess such a highly refined expertise in a specific subfield that they trust your judgment to determine whether other top-tier scientists' work is mathematically sound and worthy of publication. You are acting as the gatekeeper for the industry's knowledge base.
That is incredibly compelling evidence. The third core criteria is holding a critical or essential role at a distinguished organization.
This requires satisfying a two-pronged test. First, the organization itself must be demonstrably distinguished. In Karthik's field, this could mean an organization that has published foundational research, secured significant government funding, or whose safety protocols have been cited in federal policy directives.
And the second prong is proving the role was critical. You can't just be a researcher on the payroll. You have to be the load-bearing pillar of a specific project.
The documentation here must be very precise. It requires letters from organizational leadership detailing that the individual led a major benchmark work stream or architected a system architecture where their absence would have severely impeded the organization's ability to fulfill its critical mission.
Or its government contracts.
Exactly.
The research also mentions a few supporting factors, like commanding a high salary relative to peers, and the use of independent expert letters. Now, I want to interrogate the independent requirement for those letters.
Okay, sure.
If Karthik's most advanced work involves proprietary, unreleased models that the public hasn't seen yet, how does he get an independent expert? Someone who doesn't work for his company and hasn't signed an NDA to validate his brilliance.
This is where strategic foresight becomes essential. You cannot breach confidentiality agreements to satisfy an immigration requirement. Instead, the strategy relies heavily on the public-facing, abstracted elements of the research.
Meaning the papers he published at NORIPS.
Precisely. Even if the specific model Karthik is auditing remains highly classified, the novel mathematical interpretability framework he developed to conduct the audit can often be published as an academic paper.
Ah, okay.
An independent professor at a different institution reads that published methodology, applies the math to their own distinct research, and cites Karthik's paper.
So the independent expert writes a letter saying, I have no idea what Karthik does behind closed doors at his company, but the math he published in the public domain fundamentally upgraded how my own laboratory evaluates AI safety.
That type of validation is exponentially more powerful to an immigration officer than a letter from a direct manager simply praising an employee. It proves your influence transcends your immediate payroll.
That's brilliant.
And our legal team notes that AI safety is currently uniquely positioned for this kind of O-1A argument because multiple federal agencies have explicitly designated it as a national priority.
So the O-1A petition is meticulously built, it gets approved, and it pulls Karthik out of the lottery system. He has immediate lawful status.
This is a huge relief.
But the O-1A is a non-immigrant visa. It's temporary, it has to be renewed. For someone who wants to put down roots, buy a house, or give their children stability, temporary isn't enough. This brings us to what our attorneys call the O-1A to EB-1A bridge.
To understand why this bridge is necessary, we must examine the structural realities of U.S. permanent residency, particularly for professionals born in India. The standard employment-based green card pathways for advanced degree professionals and skilled workers are the EB-2 and EB-3 categories.
And the law dictates that no single country can receive more than 7% of the total employment-based green cards issued in a given year.
Yes. That 7% cap was originally intended to promote a diversity of origin nations in the immigration pool. However, because India has a massive population and a highly concentrated pipeline of tech professionals migrating to the U.S., the demand from Indian nationals wildly exceeds their 7% allocation every single year.
So a backlog forms. And from what I understand, for Indian nationals in the EB-2 and EB-3 lines, that backlog doesn't just mean waiting a year or two.
Yeah.
We're talking about decades.
Decades, yes. Based on current visa bulletin movements and application volumes, individuals entering those lines today could be waiting 20 or 30 years for a green card to become available.
That is an entire career span. It's completely unworkable. But the EB-1A, which is the immigrant visa for extraordinary ability, bypasses that specific backlog.
Because the criteria for extraordinary ability are so rigorous, the pool of individuals who qualify globally is much smaller. Consequently, the EB-1A category rarely hits its numerical limits in a way that creates multi-decade backlogs, even for Indian nationals. It provides a direct route to permanent residency.
Let me use a metaphor here. The O-1A is essentially a learner's permit. It gets you on the road immediately so you can drive to work, and it proves you have the fundamental skills, but it's temporary and heavily restricted.
I like that, yeah.
The EB-1A is the permanent unrestricted driver's license. You use the time you were driving on the learner's permit to build up the extensive logbook of experience required to pass the much harder final exam.
That captures the strategic progression perfectly.
But if the EB-1A is the ultimate destination and it avoids the backlog, why bother with the O-1A learner's permit at all? Why doesn't our legal team just file the EB-1A for Karthik right after he loses the lottery?
Two critical reasons.
First of all, I would like to thank the office of Chris M. Ingram for their tireless effort in making my approval a success. The process of getting an EB-1 approval was not something small, and they worked hard for months to see that it had a positive outcome. Not only were they professional and showed teamwork in their ways of handling my case, they were patient and understanding. I would like to specifically thank Damian Santoro for his hard work and constant communication with me. He is an excellent caseworker. I would recommend anyone to this law firm.
The burden of proof and the immediate necessity of lawful status. While the regulatory criteria for the O-1A and EB-1A appear very similar on paper, the level of scrutiny applied by USCIS adjudicators is vastly different.
How so?
The EB-1A grants permanent residency. It is the highest bar in employment-based immigration. An adjudicator is going to demand a much heavier volume of sustained evidence.
So a researcher might have a strong enough resume to secure the O-1A today, but they might need another 2 years of accumulating independent citations, speaking at conferences, and peer-reviewing top-tier papers to confidently cross the EB-1A's threshold.
Exactly. Furthermore, remember the urgency of Karthik's situation. His H-1B lottery failed. His underlying status in the U.S. was likely expiring rapidly. An EB-1A petition can take substantial time to prepare and adjudicate, and merely filing it does not instantly grant you the right to live and work in the U.S. in the same immediate, unassailable way as a non-immigrant visa.
Oh, I see.
The O-1A, however, can be filed with premium processing,
Which guarantees a response from the government in 15 days.
It stops the bleeding. It secures his immediate right to remain in the U.S., keep working, and retain his salary. From that secure position, he can methodically lay down the building blocks for the EB-1A over the next 2 years without the panic of a ticking clock.
It's a masterclass in leveraging the law structurally. Let's look at how this theory was actually executed in Karthik's specific case. The research deconstructs his winning O-1A petition into 6 distinct evidentiary pillars. Instead of just listing them, let's look at the narrative they built.
Sure.
They started with his original contributions.
Right. Our attorneys documented 2 distinct interpretability methods he authored. But the centerpiece of this argument was an evaluation framework he designed that had been independently adopted by a secondary AI safety organization.
The ripple effect we discussed earlier.
Exactly. But they amplified it. They provided evidence that this specific framework was formally referenced in a published policy brief by a federal advisory body.
So it isn't just pure adoption, it's federal acknowledgement. The government itself relies on his math to understand policy. That is undeniable major significance.
For the publications criteria, they highlighted 3 peer-reviewed papers. But they focused on the fact that 2 of these papers were cited heavily by researchers who had 0 professional affiliation with Karthik's employer.
Proving his academic influence isn't manufactured by his coworkers.
Yes. And to satisfy the peer review criteria, they submitted editorial records confirming he had completed review assignments for 2 top-tier conferences, establishing his role as a gatekeeper of industry standards.
And for his critical role, they didn't just get a letter from HR saying, Karthik is a good employee.
Oh, no. They secured a detailed declaration from executive leadership. This document specifically tethered Karthik's leadership of a benchmark work stream directly to the organization's ability to fulfill substantial government research agreements.
Wow.
It demonstrated that without his expertise, federal contracts would be in jeopardy.
They also utilized objective market data to satisfy the salary criteria, proving his compensation placed him in the highest tier of AI safety researchers nationally.
Finally, the expert letters. They submitted 2 highly strategic independent letters. One was from a tenured professor at a leading human-centered AI center, providing pure academic validation.
Okay.
The other was from a senior researcher at a major competing AI laboratory who had explicitly utilized and cited Karthik's interpretability methodologies in their own published work.
That second letter is the holy grail, isn't it? A competitor going on the record to say this individual's work is essential.
It completely neutralizes any argument that the petitioner's accomplishments are confined to their own company's ecosystem.
And the result of this meticulously structured argument was incredibly fast. Filed with premium processing, approved within the 15-day window. Karthik never missed a day of work. The existential dread of the lottery was completely removed.
And there was a massive secondary benefit highlighted in the legal research, too.
His wife, right, who had been restricted by an H-4 dependent visa, she was able to apply for work authorization because of the new stability this path provided.
Yes, he secured his present, stabilized his family, and is now actively building his EB-1A portfolio from a position of profound strength.
It is brilliant. But listening to the sheer volume of documentation required to pull this off, it is obvious you cannot assemble this kind of portfolio in a weekend.
No, definitely not.
If someone listening to this right now is on an H-1B or they're in their final year of student OPT training and they want to prepare for this, what is the action plan? How do they start building this record today?
The overarching principle our team emphasizes is that the worst time to start building an extraordinary ability case is when you are desperate. You must operate proactively. Based on the studies we've reviewed, there is a clear 5-step strategic plan tailored for individuals in technical fields.
Okay, lay it out. Step 1 seems to be aligning your work with a larger national narrative. You can't just be a great programmer, you have to solve a problem the government cares about.
You must leverage national priority arguments. In AI safety, this means explicitly tethering your daily work to the mandates laid out in the White House Executive Order on AI from October 2023, the National AI Initiative Act, or the frameworks established by NIST.
The National Institute of Standards and Technology. Their frameworks are the gold standard for federal policy.
Exactly. When you describe your work, you do not just say, I optimized a neural network. You say, my work directly advances the safety mandates established by NIST and supports the critical infrastructure goals of the 2023 Executive Order. You use the government's own policy language to legitimize your value.
I imagine step 2 is going to cause some friction for people who work in highly collaborative tech environments. The research says you have to aggressively track your individual outputs separately from your team's collective outputs.
This is a major stumbling block. Tech is inherently collaborative. You might be part of a 40-person engineering team building a massive red teaming protocol.
And if you submit a petition that says, I was part of the team that built this protocol, USCIS is going to look at that and say, okay, did you design the core architecture or did you just write the meeting notes?
They will heavily discount collective achievements unless you can isolate your specific contribution. You must document exactly what you authored.
So keeping receipts, basically.
Yes. Did you design a specific evaluation metric within the larger protocol? Did you optimize a particular algorithmic function? You must build a contemporaneous record of your individual authorship, because trying to reconstruct that granularity years later, after you have changed jobs or teams have dispersed, is nearly impossible.
Step 3 requires a shift in how academics view their inboxes. You have to treat peer review requests from top-tier venues as vital immigration evidence, not administrative chores.
Do not ignore them. Accept the assignment, complete the review thoroughly, and create a dedicated archive for every piece of correspondence. Keep the invitation email, the confirmation receipt, and any editorial feedback. These are the certified receipts of your industry standing.
Step 4 is about building the network that will eventually write those crucial independent letters. And this means you can't just put your head down and code. You have to engage with the broader academic community.
You must build an expert network completely independent of your employer. When you publish an interpretability paper, actively monitor who cites it. If a researcher at a university in Europe cites your methodology, reach out to them. Propose a virtual meeting to discuss their findings.
Build a relationship based on mutual scientific interests now, so that 2 years down the line, when our attorneys tell you they need an independent letter of support, you aren't cold emailing strangers and begging for a favor.
Exactly. You will have a pre-existing network of peers who intimately understand the value of your work and are willing to attest to it formally.
Which leads perfectly to step 5, start the O-1A conversation with qualified counsel long before the lottery cycle even begins.
The strategic leverage you possess when your current visa status is secure for another 2 years is vastly superior to the leverage you have when your status expires in 30 days. Early consultation allows you to identify the gaps in your portfolio and actively pursue the speaking engagements, publications, or peer reviews necessary to close them.
Now, we do have to cover the caveats laid out in the legal research. The O-1A is incredibly powerful, but it is not a magic wand.
Definitely not.
First, it requires an employer or an agent petitioner. You cannot sponsor yourself for an O-1A the way you can for an EB-1A. Second, it requires documenting true, objective, extraordinary ability. Being a highly competent, hardworking engineer is not sufficient. You must prove influence.
And perhaps most critically, you must maintain underlying lawful status throughout this process.
You can't let your visa expire, overstay, and then assume filing an O-1A petition will retroactively fix your immigration record.
Unlawful presence is fiercely penalized by U.S. immigration law. Once you fall out of status, your options evaporate almost entirely, and adjusting your status from within the United States becomes exponentially more difficult, if not impossible. Proactive planning is the only defense against this.
This entire deep dive really forces you to reevaluate the narrative of your own career. We're often conditioned to be humble, to emphasize the team's success over our own, and to view our innovations as simply doing the job we're hired to do. But the immigration framework demands that you look at your daily output through a lens of undeniable singular impact.
It requires a paradigm shift in how you document your professional life. Understanding the mechanics of the O-1A and the strategic bridge to the EB-1A empowers researchers to take agency over a process that otherwise feels terrifyingly arbitrary.
So let us leave you with the heart of it. Yoshua Bengio's family moved from Casablanca to Paris, from Paris to Montreal, and he moved from Montreal to American research institutions and back. And from that base, built a career that changed what artificial intelligence can do and how seriously the world takes its risks. He has warned that the investment in making AI more capable is running far ahead of the investment in making it safe. The researchers in the United States working to close that gap are doing some of the most important technical work on the planet right now. Some of them are on H-1B visas. Some of them have no idea that the O-1A and eventually the EB-1A can give them the stability to keep doing it. So here's our question for you, and keep it general, no personal details. In your field, what is the one credential you think gets overlooked when people judge their own record? If you want to see how a record like Karthik's gets built into an O-1A and then into a green card, visit breakthroughosa.com. The law offices of Chris M. Ingram have spent more than 2 decades building immigration cases for exceptional researchers at the frontier of their fields. And here's where we are headed next. An extraordinary ability case lives or dies on one thing most researchers get wrong: the expert letters. And next time, we open up exactly what separates a letter that carries a petition from one that quietly sinks it. The difference is not who signs it. It is something almost nobody plans for in advance. The strategies in this discussion are for educational purposes only. Your situation is unique, and the law offices of Chris M. Ingram are here to help you understand your specific options. If you would like a clear assessment, visit breakthroughusa.com. Thank you for listening, and we will see you next time.